So I would like to thank you for accepting our invitation, and also extend my thanks to Professor Lombardi for organizing this. So on behalf of the School of Law of Euclid Cyprus and in association with the EU and FORCE, who are our partners, welcome everyone. And I would also like to thank our guest lecturer and Professor Lombardi, who is also co-teaching along my side on private international law. So the topic for today's presentation is on recognition and enforcement in private international law. So we have a number of students with us, and we also have practitioners as well, and advocates.
Not only students.
Not only. So it is, we have practitioners, advocates, and some students as well.
Coming from different states, from different countries.
From mainly Cyprus, as far as I can tell, but I think we have practitioners that originally come from different countries, as far as I can see.
Okay. So tell me, can I start?
Of course, whenever you're ready.
Because as I understand, we are supposed to go on up to your 3 p.m. maybe.
Ours would be 4 p.m. Yeah,
time.
But you can keep with us as long as you want. We have maybe a 10
I don't want to bore you.
Session for us in the end.
I don't want to bother you too much.
Whatever you feel comfortable with in this part.
Especially because, and now I am going to start, because this is a very complex and difficult issue. As I may say, the recognition and enforcement of foreign judgments is one of the most difficult, critical stage in the international litigation process. So it's even difficult to break down in different fields, in different points, but I'll try to do without being too technical if possible, just to understand first of all, what is the recognition and enforcement? And generally, recognition and enforcement of foreign judgment is a complex field, and it involves a variety of approaches of other jurisdictions, bilateral and multilateral conventions, and jurisdiction-specific procedural laws, rules, and regulation. So you must keep in mind that sometimes just to understand and to adjust the meaning of a word, juridical, legal term included in a law, we must refer to the country legal culture. And so it becomes very complex to understand and to interpret it. Because the approach for enforcement of judgments is widely different around the world. We must say that over those latest 2 years, the COVID issue made even more complex this process of recognition and enforcement, because all legal systems had to face additional problems and to delay a number of proceedings, including trials in many countries, and sometimes with a number of dramatic delays. I noted that even in England, for example, where they are generally respecting very strictly the times and the terms of trials and proceedings, they had to face difficulties because of the number of the rooms, of the court rooms. And so there were many delays in trials, in proceedings, in hearings. So this was just maybe, as I understand, for example, in some country, if I don't fail, in Greece, for example, there was a suspension of enforcement and recognition of judgments. And not only in Greece, even in other countries all over the world, because obviously the problems, the COVID caused a number of additional problems. Certainly, we have to say from a general point of view that problems with the recognition and enforcement of judgments are affected even by general problems of jurisdiction. For example, in time of crisis, these kind of problems increase generally, and in this apart from this COVID problem and these crisis problems, we have to understand that in this particular field, recognition and enforcement of judgments, we have, on one hand, the tendency, at least of majority of countries, the tendency to increase the cooperation. But on the other hand, some concern to preserve our specificity in terms of legal system, with the concern to peculiarities that this particular mechanism of recognition and enforcement may in a way put in danger for some reason. And in this kind of mechanism, recognition and enforcement, I say recognition and enforcement because they are strictly linked. So when I talk about recognition, generally we talk about enforcement, even if we can certainly, one can certainly ask to have a recognition without having an enforcement. But generally, the aim of recognition is the enforcement. And I'll try I try to make a general overview about the recognition and the enforcement in European countries. Maybe I will make some reference to a specific country, just like Italy, for example. And then, as Professor Lombardi asked me, not only in a general, as a general overview, but only even to the English situation, because we are generally talking about European Union situation, European countries at least. But first, after the Brexit, we have a number of problems about recognition and enforcement of judgments in England, if not in UK. I will try to say something more about it. From a general point of view, I want to say that before I talk about European Union regulations and convention and directives, I want to mention the Hague Conventions, because they are particularly important. I mean, the convention in 2005 and 2019. The Hague Convention, because this provide an alternative to the Lugano Convention 2007, and the Hague Convention 2005, the so-called the Hague Convention, provides for a simple mechanism of recognition and enforcement of judgment when the parties have agreed an exclusive jurisdiction clause. This is not only for the Hague Convention, because we have, in a way, some particular rule about exclusive court even in European Union regulations. I will talk about it later. But this is more important, certainly important, as I know currently United European Union states, Singapore, Mexico, and Montenegro have ratified this convention, and even the UK will likely do so in after the European Union Brexit, with and this is as I said before, the Hague Convention is very important because it's a general mechanism applying to all cases and where parties agreed for exclusive court and the jurisdiction. That is a crucial point, the choice for an exclusive court jurisdiction. But coming to the recognition and enforcement of foreign judgments, I want to add that I'm just talking about civil judgments, not criminal ones, because the recognition and enforcement of criminal judgments is a different issue, even more complex, and has to do with different conventions and different principles. But starting from the civil and commercial matters, the first because we are talking generally about conventions and regulations. In the past time, there were also bilateral agreements, and even historically, we have to say that this bilateral agreement was maybe the first mechanism from an historical point of view. But now it's largely more common to have a convention applicable for different and many countries with different requirements only. I say hello to Professor Lombardi. I can't hear your voice. I can't hear your voice.
Marcello, hi, how are you?
Fine. Fine.
I don't want to interrupt you. I'm here.
No. I just want to say hello because I was welcomed by Professor Tatsiou.
Yes.
Very kindly, I apologize I had a bad pronunciation of your name, Maria Tatsiou.
No, it's not about the pronunciation. I am still a doctor. I've not reached professor yet, but it was fine.
Yes, but but the same for your name. I don't want to make.
No, it was fine. The name is absolutely fine. Don't worry about it.
I said I just started. I say to Professor Lombardi, I started talking about, in general, about the difficulties we have to face when talking about recognition and enforcement. A crucial, difficult, and complex issue. Really very difficult. One of the most complex of international private law, certainly. But I started mentioning the Hague Convention because it's a general mechanism that is becoming more and more applicable and useful in resolving this kind of difficulties because of the mechanism of the choice of a common court of jurisdiction agreement, an exclusive court, exclusive court jurisdiction agreement. So I come to the civil and commercial matters, and without starting from the the 19th century, I don't want to say something about this, just more recently, the more common conventions, because there are even customs and rules maybe applying from a very ancient time, but it's not particularly useful to talk about them apart from an historical point of view. Now, I want to mention Lugano Convention. Lugano Convention 2007, that is really important and one of the first general mechanism and convention for recognition and enforcement of foreign judgments. And this involves also countries not directly involved in European Union instruments, just like Switzerland, Iceland, Norway, Denmark, for example, because Denmark has a particular position, even being a member of the European Union. Lugano Convention I already mentioned because has also a relationship with the Hague Convention. But now, then one of the most important, one of the first really important convention, or better regulation, and more regulation, the Regulation 44 2001, so-called Brussels I regulation, replacing the 1968 Convention of Brussels. So this is a general convention to apply in European Union the recognition and enforcement of judgment. And the scope of this regulation is applicable to judgments rendered in European Union member states, irrespective of the nature of the court. That is important to do, because we have to do, you know, certainly, with different kind of courts, different range of courts, different ranking of courts, because there are sometimes convention requiring that the judgment may be issued as a final judgment. Not always, but sometimes we have to go to that. This is the first and, in a way, one of the most important convention, not only from an historical point of view, but even because it's largely even now applicable as a regulation. But then we have another Brussels Convention, the Recognition and Enforcement Brussels 1bis, so-called 1bis Convention, because this convention introduced meaningful change. Enforceability certification is no longer needed after this second Brussels Convention. There's no need for a separate recognition proceedings, so we generally define it as a de plano recognition. And judgments have the same binding effect and force of any judgment of the country of the court of origin. We need only a copy of the judgment and the certificate by the court. So Brussels I and Brussels 1bis compose a complex and complete, in a way, mechanism of application for European Union countries. Because prior to Brussels 1bis, Lugano and Brussels I required the so-called exequatur. And this was certainly an obstacle, more than an obstacle, another step to do. So, because one of the most important aim many countries have in this process of conventions and agreements is to reduce the steps we have to do for recognition and enforcement. And because historically it was the worst problem that courts, judges, and even persons had to face in this field of action. This is the the system we have, the double Brussels system. I want to add some restrictions to recognition and enforceability in this system. The subject matters excluded because there are different mechanisms, not excluded, not always at least, because they are not enforceable, but because it's not using this kind of convention. So revenue, customs, administrative matters, liability of the state, status or legal capacity, and this is something that has to do with parental responsibility or relationships that are governed by different rules. Rights in property arising out of matrimonial relationships, social security, bankruptcy, arbitration, maintenance obligations from family relationships, parental marriage or affinity, and wills and successions. So we have to be careful in using these conventions, but in a way strictly meaning civil and commercial, it makes sense, the exclusion of these issues, these subject matters I mentioned. And I said that there was a significant improving in the second Brussels Convention. But we have to keep in mind that there are grounds for challenging recognition or enforcement. Based on historical or even less historical reasons. The first one is the case of judgments manifestly contrary to public policy. This is an historical issue coming from the past, and so-called now international public policy. It would be difficult, at least for me, extremely long process to explain, to go deeply into the concept of international public policy, because we have in our countries, in each of our countries, the public policy. But to talk about the international public policy is something different. So we have to look at the case load of each country and even of the international courts to understand better that. So this is the first obstacle, the first ground for challenging the recognition and enforcement. The second one, that is in a way related to the first one as a specific application of that, is the problem of default judgments. Because this ground for challenging is related to cases where judgments by default were issued where rights of a proper defense were not granted. And in terms of service of the claim, e quindi so a judgment by default in this way. I must say that I've been studying for a long time the English legal system, and in particular the English procedural legal system, as Professor Lombardi knows, because we are frequently discussing about it. And so it's difficult even for example, for an Italian non-English speaking and non-English legal system expert lawyer to understand what is judgment by default. First of all, the term in itself, default, is something that relates to some fault. What is, yes, because it has to do even with the custom, with the history, with the culture of a country. For an Italian, for example, to lodge a defense is not a fault. It's just completely usual. This is the same in other countries when even where they are called judgment by default. But I mean, I would say the culture of origin of these terms is different. And judgment by default is something that is really extremely difficult to understand for a civil law lawyer because it's not simply a judgment where one of the parties did not defend the case. We have the same, we say, in absentia more than by default in civil, but even in criminal cases. The difference is also related to the evidence giving, because in the systems where judgment by default is very common, the evidence may be related just, if not simply to not defending, to the self declaration of the truth of the facts included in the claim. In a way, it will be a long process to understand this kind of mechanism, but there are significant differences between judgment by default and judgment in absentia, in contumacia, we say in Italian language. So different countries have different, I may say, sensitiveness about the meaning of a judgment by default and the way a judgment may be issued without hearing a proper defense of the other party. And so challenging the recognition and enforcement of a judgment from this point of view may be in a way effective sometimes, but it requires a long process and a difficult process to give a judgment on this kind of judgment. Another, I had to pass quickly to the other cases because I know that maybe because of my interest, I tend to stay on this kind of issue, procedural issue, too long maybe, so I apologize. But another case is when judgments are in conflict with other judgments already issued in European countries involving the same cause of action. Another term that would require an explanation, maybe not for you, because as I know, all of you are perfectly understanding the English system, and all of you are practitioners or graduated in legal sciences, in law, and so there's no real problem, particularly in your specific expertise. So another reason to challenge the recognition of a judgment are the rules of jurisdiction, in particular rules of exclusive jurisdiction. And whilst limitation is not really a problem, the time limitation, because it's generally we have to refer the same time limitation for domestic enforcement. So this would be difficult, less difficult as a problem to face. I want to mention one point of the new Brussels 1 bis convention that may be extremely interesting because it's the introduction of the exclusive jurisdiction clause that is related to the Hague Convention I mentioned before, replacing the jurisdiction of the court where the case was firstly filed. And this mechanism may be, in a way, useful in reducing problems and discussions and even the need for a judgment on a judgment, just to understand when we have to go ahead. The enforcement, having said that about the recognition, just a short resume, I must apologize because each one of these points may request one day explanation just to understand the terms. It may be fascinating, but in a bit boring, maybe, for some of you. So let me excuse. Sometimes I say something just to have to relax, because as I said before, this field of study is extremely, we say in Italian, heavy. Just to not only to understand, but to follow. And so this is the reason why at least now I didn't mention just one, maybe once or twice, a number of an article.
Marcello?
Tell me.
Sorry, but your wiseness is so high that you are able to make it lighter, even so.
Too kind.
Because yeah, I'm taking notes because it's very, very interesting what you are saying. So as usual.
As they say in England, how kind of you. But coming to the enforcement is less complicated because the enforcement is governed by the law of the enforcement country. So generally, for example, in Italy, the bailiff system, or and certainly in general, having a copy of the certificate, generally also a translation, because translation is needed almost by everywhere. Another important, apart from these two conventions, an important, an additional important regulation is the 805/2004 regulation, the introducing European enforcement order for uncontested civil or commercial claims. So I want to read the Article 1 of this regulation. This is very ambitious. The purpose of this regulation is to create a European enforcement order for uncontested claims to permit, by laying down minimum standards, the free circulation of judgments, court settlements, and authentic instruments throughout all member states, without any intermediate proceedings needing to be brought in the member state of enforcement prior to recognition and enforcement. It would be reading this article, we may think that there's no other need to have another legislation, because having that we have all. But unfortunately, this the scope is not such a general one. Yeah, in a way, it's general because shall apply in civil and commercial matters, whatever the nature of the court or tribunal, as for European Union conventions. And in a way, there are the same obstacles and exclusion cases I mentioned for European conventions. But it is interesting that I want to say it's important to understand exactly what must be regarded as uncontested, because it's the obviously the center and the crucial point. A claim, say, the Article 3 states that a claim shall be regarded as uncontested if the debtor has expressly agreed to it by admission or by means of settlement, which has been approved by a court or concluded before a court in the course of proceeding, or a debtor has never objected to it in compliance with the relevant procedural requirements under the law of member state of origin in the course of the court of proceedings, or the debtor has not appeared or been represented at a court hearing regarding that claim after having initially objected to the claim in the course of the court proceeding, provided that such conduct amounts to a tacit admission of the claim. I don't want to go to add more cases, but even now I want to repeat what I said before about the culture behind the articles and the contents. This is a really an English culture, legal culture, because you know that apart from judgment by default, there are in the CPR rules about the judgment by admission, for example, another kind of peculiar case of judgment, not only default but even admission, that is defended not properly with a proper defense but just by an acknowledgement of service. This kind of different and less complicated way of defending, and maybe including conditions, requirements in order to admit, to accept. And this is one of the reasons why I said that to read properly these texts, we have to at least have, if not a culture, a general understanding of different countries' legal culture. Otherwise, it will be misleading many times. And this is one of the reasons why foreign lawyers sometimes talking to each other without understanding properly what they are saying, and making tragic mistakes in defending their cases. That is important, and I hope that your university, for example, as I understand it, particularly interest to the exchange of cultures, exchange of experiences, may improve because of his characteristics, may improve the knowledge of a mutual knowledge of legal culture between different countries of Europe, and not only of Europe. I think that will be a fascinating field of study, because it's a prerequisite to understand each other and to study different countries' legislation. So in this important convention, as generally happens even in European legislation, we have definitions of judgment, claim, and so on. But this convention contains rules of the abolition of exequatur, certification of European enforcement order, and so on. There are many important rules in this convention, and the regulation 805 I think is important to study, not only because of the rules in itself contained in that, but even for the language and for the way it addresses this problem. I think it's important even from a legal culture point of view. I pass very quickly to another point because time is passing, and I don't want to go ahead up to the end of the time without having the time even for exchanging some opinion with you and Professor Lombardi, that I obviously is welcomed to give our his opinions, even interrupting me when he wants. So another regulation that I want to mention is Regulation 1896 of 2006, European Order for Payment Procedure. And another one, Regulation 861 2007, that is important even as a common mechanism, procedural mechanism, this European Small Claims Procedure for cross-border civil and commercial claims. We have, in this case, an additional step, not only recognition, and not specifically a recognition and enforcement, but the establishment of an European instrument, a common judgment to be applied by everywhere. And that is, in a way, an ambitious aim, obviously with the limit of the value, 2,000 euros as a maximum value. But if not for the number of cases, for the importance in itself of the mechanism, I have to mention it. Another regulation that I referred to before while mentioning the exclusions is the Regulation 2201 2003 Brussels 2 bis regulations, so-called 2 bis, about divorce, separation, matrimonial and parental responsibility matters. At the end of this listing of conventions and regulations, we have to say that at least looking at the European Union tendency and history of this process of the conventions, as mentioned by the so-called Stockholm program, at the end of the process, there should be a system where no distinction between recognition and enforcement will be more existing. So the end of the process is the unification of the idea of enforcement and recognition. That is, we possibly would be the end of the process. If I want to say something, I want to add something about Italy, just to say that we have just a very short remark. For the Italian, apart from the general conventions I mentioned, the rule and regulations, The recognition and enforcement of foreign judgment in Italy is governed by Article 6.4 and subsequent of the Private International Law Act, number 218, 1995. That is a complex and unified legislation which replaced some provisions of the Italian Civil Code, Civil Procedural Code, and Civil Code. So it was an important text unifying these rules and applying, obviously, where no convention is applicable, apart from the case we have, because there are countries, one of them is, for example, United States, where we have not to apply this covenant. Maybe sometimes we have common conventions, even for different countries, but not this specific body of rules I mentioned before. And even for this for the Italian legislation, there are obstacles and requirements, and in a way is a legislation that is not contrary to the rules I already mentioned in the European conventions and even in the other conventions I mentioned. Is in accordance with them. And I would say that just to give an example of this notion I mentioned before, the international public policy and the domestic public policy, just an example, without giving, without entering all the problems we have to discuss about this issue. The Italian Supreme Court declared as not in violation of Italian international public policy the American rule which recognized the validity and enforceability of prenuptial agreements in contemplation of divorce in a case concerning an American couple. So this is just to give an example of what in practice means international public policy related to the Italian or domestic concept and notion of public policy. Another important issue would be the enforceability in Italy and in Europe of foreign temporary orders. This is even more complex in a way, because there's no a large amount of decisions about it, especially for seizure. This is the main field of application of the temporary orders about confiscation, seizure of goods, assets. That is crucial in terms of practical importance for parties. According to the Article 35 of Brussels 1bis regulation, this is not obviously the domestic Italian legislation, but the Brussels 1bis, the second, the recast Brussels Convention. Application may be made to the courts of a member state for such provision, including protective measures as may be available under the law of the state. Obviously, and we would probably need to understand more about the international, the interim reliefs application and enforcement as a separate lesson, maybe, because I think that in a few words it's difficult to address this, because it's, especially because it's a case by case study, and we would have to explore different cases, different judgments to understand more about this point. When when I started, I said that I have been asked. I think in the title of the lesson on my intervention, we mentioned the application of the enforcement of judgment in Europe and even in the United Kingdom, or at least in England, that is really a little bit pretentious for me to talk to you that are generally coming from England or English course related and expert to say to you something about your proper experience. But maybe this is my point of view, the way an Italian studying a different system may look at this system. And I remember that in an article I read about the enforcement of foreign judgment in England, they started saying, when you ask an English lawyer whether and if, so when a foreign judgment may be enforced in England, they reply, it depends. So this is not completely good for a person without not precisely knowing what happens in English courts, but it is the right way to reply. First of all, because of my personal interest on the history of the English law, I must say that the common law approach to this problem, because there are different regimes by the regimes using to enforce a foreign judgment in England. There are different cases, different approaches, but the more historical way is the common law approach. And this is very curious from an Italian point of view, at least, because the common law relating to recognition and enforcement is not only a cultural point, because applies where the jurisdiction from which the judgment relates has no treaty, has no convention applicable in UK, for example. It's not only a theoretical point of view, cultural, but even practical. And even in the absence of any applicable UK statute. According to common law system, a foreign judgment is not directly enforceable in England. As a foreign judgment, at least, I hope to be understandable. But is taken as it is the reason to create a contract between the parties. So a very peculiar way to enforce a judgment without looking at that as a judgment, but creating a contract. So the point is to understand how to apply this contract in England. This is the common law, at least as I understood the problem. For this reason, the foreign judgment must be final and conclusive, and has to be not on procedural matters, but on the merits of the case. The creditor, because it's a matter of creditor and debtor, needs to bring an action for a simple debt. And generally speaking, the mechanism used is a summary judgment, not the trial. I don't need to say some more to you, because you perfectly understand what is a summary judgment. This is a very important case, a very important point for me, because I studied 4 years the English system just to understand properly, if not properly, at least sufficiently, as far as I can, the distinctions between different kind of judgments. And now, in a way, we are approaching, because the trials are disappearing, are fading away, as Galanter said a number of years ago. And so almost all judgments are pre-trial judgments, and sometimes summary judgment. So this is the way, in very simple words, I would say the enforcement of judgment may be seen in the English system by the common law perspective. So very peculiar, as I said before, because it's not treated as the enforcement of a judgment, but transformation of a judgment in a contract, just to be applied. So, in a way, it's a very interesting and flexible approach to make it possible to do something that in a strict way is not provided in a system. This kind that it is objective, flexible, may be frequently used in the legal system in a good way. I say in a good sense. I don't say flexible as something that is not proper. So apart from that, we have different system apart from the common law approach, different systems to apply, to enforce a foreign judgment in England. First of all is the Hague Convention I mentioned before. Obviously, all of those systems are applicable as far as they are concerned in the case we have to apply. Then Administration of Justice Act 1920, because it relates. There are, I think, even now cases where this act may be applicable because it has to do with enforcement of money judgments given in certain foreign states, especially states where that once were formerly in the British Empire. And for example, the Cayman Islands, and even maybe, if I don't fail, sometimes in Cyprus may be applicable, sometimes this Administration of Justice Act 1920, as I found in some reference in the English books about this point. Then another source of legislation of these cases maybe the Reciprocal Enforcement Act 1933, as many times happens in England as in the ancient Rome Empire. Legislation does not fade away because of the time, but we may refer to that. I remember once I was in an English court and I was listening to a defense based, because of the case was the poisoning or even damages, an application for damages for because of subterranean problems with pipes, with something like that. And I understood that the judgments they quoted was based on the Judas tree poisoning of a horse in 18th century. So starting from that, the application of this principle was even for different cases, but based on the same reason, on the same source. So this is 1931, so 33 legislation, the reciprocal enforcement, conclusive money judgments. I mean, conclusive, not subject to appeals, to apply this kind of recognition and enforcement. This is just an example of different ways to apply, even in England, the enforcement and the recognition and enforcement. Apart from the special legislation for Brexit, because the application of these conventions I mentioned before, Brussels I, Brussels 1Bs, was one of the points discussed during the Brexit discussions and treaties. So there is a distinction between cases before or after 2015. And now maybe there will be additional changes in these regulations. And these probably might be and had to be the content of a different seminar or lesson, because it's very long, difficult and complex, at least for me. I would say that I have just, sorry, I tried to give you more than an overview, a personal overview about this issue, because as a judge, in my former capacity as a judge, because now you know that Professor Lombardi introduced me also as the chairman of the arbitration panel of the ABF in Bologna. That is one of the 7 panels we have ruled by the Bank of Italy about the banking and financial disputes. But in my previous life, I was, no, because, you know, one lives only twice, as James Bond said. So in my previous life, I had no many cases to apply this kind of legislation. And when I had to do it, it was extremely difficult, because not only me, but even lawyers were not particularly expert of this. And you know, the Italian legislation has a rule in a way approaching the same rule in England they have in England for rogatories, for example, and in criminal cases. You may hear, the court may hear an expert to understand the proper legislation to apply. This is maybe the only case in which an expertise may be done in Italian. I mean, a court expert, differently from the English experience of the 2 experts, apart from the recent introduction of the joint expert. But the joint expert is nevertheless the joint private expert, part expert, more than private, because it is not the same. But I'm talking about a court expert about the applicable law. And I don't know how many times Italian courts used such a rule, but I know that sometimes it happened, and I see that Professor Lombardi is a way skeptical, at least
No, Marcello, I called you Marcello, not Presidente. Yes, I'm a little bit skeptical because if we apply the principle iura novit curia, in this case we are giving to some other person, like a third party, the possibility to understand which one is the law that we apply. It sounds a bit like delegating someone else, or as well an expert or something like this, to decide which one is the law to apply. And it's like if the judge is not able to understand which one is the rule to apply. So that's why it's making me a little bit skeptical.
I think I must be more precise because the provision relates not precisely to the conflict of laws and the enforceability, the condition, just to the contents of the foreign legislation. But in a way is strictly related to the point of recognition and enforcement. But I think it's an honest recognition of the fact that we cannot know everything. So
you're right.
And we would be honest even more than in these cases, and to recognize when we are not able to say something properly because maybe we need more time to study, we need more opportunities to understand more. But even legislation is not an homogeneous field of study where you, as a professor, for example, are requested to know everything in legislation. I don't know. I'm certain we cannot say it. So, in particular, in that legislation admitted that court may profit from an expert opinion. And Professor Tatsiou, what is saying about it?
To be honest, I have never heard this particular part before in English proceedings about assisting how to, like, what law they should apply. What I have observed in general is that English judges tend to they want to take jurisdiction over matters. They want to take matters in their hands. So they're more willing, for example, to assume that an English court would have jurisdiction and then perhaps even apply English law compared to other, like, let's say, French law or Italian law. They have developed these different tests that I think they're going to become even more prevalent now with Brexit, because we're moving away from the control of the Court of Justice of the European Union. So I think it's going to create a chaos. And you mentioned earlier, sorry, it's a different topic, but about the fact that from 2015, there is some discrepancy as to whether judgments should be recognized or not in England. And that's absolutely correct. That it has to do with Hague Convention that you touched upon earlier. But again, that's another problem because the EU believes that the UK ratified it in 2020. The UK's position is different, so I think it's gonna be it's something that we could discuss for ages and not even come down to a plausible solution. But yeah, going back to what you mentioned about the court expert, the only experts that judges tend to use is mainly the private experts, for example, a medical expert or something that they do not have the capacity to understand outside of the law.
Yes.
But yeah, I think it comes down to the prerogative that judges have in England. Yeah.
But even in England, they can do it because, in principle, I want to add that the contents of the foreign legislation, I remember that even the comments of this Italian legislation I mentioned said that the foreign legislation is a matter of fact, so it's a matter of evidence. This is the difference between the Iura Novit Curia that is related to the internal domestic legislation. The foreign legislation may be studied by an expert because it's a matter of evidence. And even in English courts, I attended some case in the for example, the courts for extradition. Near the in the past it was just near the Covent Garden, this court applying to just to recognize the foreign judgments to extradition, and frequently there were Italian lawyers, professors, as witnesses to describe the Italian legislation, because the lawyer of defense said that the Italian legislation was against the human principles, against the common human rights principles. So the court admitted and accepted to hear an Italian lawyer about the contents of that. So just it's not a curiosity. This problem is important because it reflects the difference between the domestic law and the foreign law. Domestic law, as Professor Lombardi rightly said, cannot be a matter of evidence, because Iura Novit Curia, at least should Novit Curia, should know legislation, to be honest. But the foreign legislation is a matter of evidence. So I don't know whether we finished our time.
Marcello,
I was too boring. Maybe I was too boring for you.
No, it was very interesting. I don't know for Maria, but I think so.
Yeah, I absolutely found it very, very helpful, and it actually builds on what we have covered during the course, and it's also nice to see it from an Italian perspective, not only the English one, because you have touched upon the English one, and I was like, yay, okay, that's great. So it's also something that we discussed last week when we were covering Brexit, because this matter of mutual trust that exists in the European Union, and we treat matters as res judicata, and we have the lis pendens and so on. So it's something that is going to create problems, especially for the English courts and for people like the creditors or debtors. So I found it very, very interesting for me, to be fair. And And I think it's very important to know where we stand, because on the one hand, yes, we are a British university, but on the other hand, we're still a member state of the EU. So it's very good to see both perspectives.
Yes, and especially for procedural law, it would be interesting. You may host a debate, a panel between Italian or not only Italian and English, just to reflect on the different mechanisms we have to apply, especially, for example, as I said about the judgment by default, judgment by admission, and so on. That is barely perceived in my country.
Marcello, may I ask you two things? Or maybe may I make a very quick reflection on what you said, a very quick thought. So something was very interesting for me when you said the transformation of judgment in a contract. Well, yeah, but it's true, because if we consider recognition and enforcement, it's really the transformation of a judgment in a contract, in something that is dealt by the parties, putting as well in this combination a third party that is a judge, a foreign judge. So it's a very interesting expression that you use, very smart, as you are always, and that describes very well this procedure. No, but that's true. Very interesting. And then what I would like to ask you is, Marcello, of course, you don't have the possibility cast, but just according to your experience, then it's an experience of 40 years and even more, what will be the impact of digitalization in this process of recognition and enforcement? So do you think that digitalization, so the possibility to use means like technologies like we are using today, can be as well regulated and can be implemented and used as a way to facilitate, make it easier recognition and enforcement, or it's something too far and is not applicable so far because it's too complex as a matter, as you described very well, and so it's not practicable.
I think that may be certainly used as it will be used in other fields. In particular for European conventions, because European conventions may be reduced to homogeneous box contents, questions and replies, to be even inspected by the artificial intelligence systems. Not only that, because there will be certainly the need for a supervision by a person, by a judge, but when the legislation is homogeneous and when you have the possibility to use the same terms, meaning the same contents, you can do it. Differently in different cases where you have to understand properly the meaning of a word, of a legal provision that is not very easy, even though many experts say that even in those cases, in the future time, we will use artificial intelligence resolving all cases. I'm certain that artificial intelligence may play a significant and even decisive role in instructing case, in preparing case, reducing dramatically the time you have to spend to put together all materials to decide, more than to decide the case. But even in these cases, once you have prepared a proper form, including all the requirements, when you can use the same words to mean the same things, you can certainly using technology and even artificial intelligence to do it.
Very, very interesting. Thank you, Marcello. Because Maria, I would like just to tell you something regarding Presidente Marinari. Presidente Marinari is an expert of artificial intelligence. He was
Not an
conducting.
expert.
Yeah, but it's true.
I study.
Yeah, he studied everything, so he's an expert.
Try to study.
And he was invited as well by Oxford University, Cambridge University for giving seminars on this profile. So he's very humble. He doesn't say, but he's an expert. Really.
Yes, I remember. I was part of a panel including Professor Hodge, Christopher
Yeah.
Hodge, and the Wolfson College in Oxford. When we had the pleasure, the opportunity to hear from Professor Piatek, that is Steffek, that is a German professor, but a professor in England, about the artificial intelligence. And plus, I studied the books of Richard Susskind, who is in a way a prophet of this this technology, and because he predicts trials with the holograms, replacing persons, and maybe even replicants we may have.
Well, it's a little bit exaggerated.
No, but I don't want to joke, because this is a very serious thing.
Yeah.
And regardless our personal way to think of it, they will replace many of the ways we currently do the same things. I'm certain because it has not to do with the wills of lawyers, judges. It has to do with technology and use of technology in the society, in the system in itself.
Yeah, absolutely.
I remember, and we have to be open. I remember, I want to conclude with the Peter Gabriel song. When he says, when he says that I have to move on to be stable. Because, yes, because we have to adjust our principles that remain the same, but in a different way. This means to be stable.
You're right. Absolutely. It's like as well the expression of gatto pardo. Let's think that everything is changing without making any change, basically.
Yes.
You're right. Maria, well, if there are no questions, do you see any question from the chat as well, from the students, or?
We can open the floor for a couple of minutes if anyone wants to ask a question. I can see Stéphanie being here.
Hello, everyone. Apologies for not being able to be with you from the beginning.
Professor
I have
Stéphanie.
very much, and welcome, Ettore again. Welcome, Justice Marinari. It's such a pleasure to have listened to you, especially what I caught, which was on AI, which is, of course, one of the areas where I am trying also to make a difference. So I'm very happy to, discuss this outside of this guest lecture and how this can influence more than what we think. Actually, I even came to Florence for this, to actually work on AI at the EUI. So happy to discuss this as well. It's such a pleasure to conclude this series of guest lectures that both Ettore and Maria organized with such high-profile speaker, but all three, of course, were very high-profile guest lecturers. We are so grateful. The students are very grateful, but also our external guests who have been able to join us. Most of them are lawyers, And not only from Cyprus, I can see some people here from the UK. So I think we've tried to make a real difference in the way we connect with each other and we discuss empirical work and empirical research, like the one of Justice Marinari. I can only, say a big thank you also for being able to meet new colleagues and of such caliber. We have learned a lot, and I'm very happy, to follow up in any possible way for everyone's benefits. So thank you so much, everyone.
Thank you so much, Stephanie. May I say Stephanie?
Of course, Marcello.
So, and I hope that will be not the end of our meetings, but a way to keep in touch for future opportunities.
That would be absolutely amazing. You are very welcome to visit Cyprus. And of course, we are also very keen on visiting Italy. And yes, there is a lot we can do. We have other colleagues who work on areas of law that are very close to what you do back in Italy. And we normally, under normal times, let's say, COVID-free times, we encourage our students very much through mooting activities, arbitration moot, but also mooting activities. We participate to international moots, international arbitration competitions. We are very keen also, and we offer mediation courses, and we participate to mediation competitions. So these are areas where I know that Ettore has a lot of expertise, and of course, all our guest lecturers had as well. So very happy, to extend an invitation to be able to do something for the benefit of the students and the legal profession as well.
Thank you so much. You were too kind. I'm just, me personally had this opportunity to learn more and to get in touch with such an important university and full of interests and modernity. And thanks to you and to Ettore Lombardi, who gave me this opportunity, and I will certainly meet him frequently because of other reasons. But from now, I'm certain we will discuss also about the activities of the UCLAN University.
Thank you very much. I will send you a European project which is exclusively on artificial intelligence and human rights. It is now concluded. It's a huge project, and I think you will find it extremely interesting because it's extremely interdisciplinary and also very useful for legal practitioners and the judiciary.
Thank you. Thank you so much.
Very nice. Thank you, Stephanie. Anyway, I would like to launch a nice idea, because some months ago we were discussing with Presidente Marinari about the possibility to make a congress, a world congress. And well, why not to do it in Cyprus in September? But we can discuss about it in the next weeks and months.
Okay.
Very happy to host any type of congress. We actually have already hosted congresses from Italy to Cyprus, from colleagues in Milan. So very happy to repeat this and welcome you, of course.
Thank you again.
Thank you.
We're used to this.
Stephanie, we'll speak about it. Maria, Stephanie, thank you very much.
Thank you, Justice Marinari.
Ciao Ettore, a presto.
Ciao. Bye everyone.
Bye.
Bye.